Thank you all for coming back from lunch. For those of you who were here at the first panel, let's see how the blood sugar effect will play out in our deliberations. I'm more concerned about your attention, actually. So, thanks to the organizers for inviting us to this conference and this panel. It's been a pleasure so far, and I'm sure the remaining panels will also be as interesting as the first ones. Back in 1958, the drafters of the New York Convention were aware of the many differences among national laws on the Kompetenz Kompetenz principle and kept the regulation of this principle to a bare minimum or to nothing, according to some commentators. One may say by wisdom, others by lack of time, who knows. Since then, many international conventions, as well as the ancestral model law, have recognized the basic idea that arbitrators have the power to decide on their own jurisdiction. But still, until now, national laws vary greatly on their approaches to Kompetenz Kompetenz. They differ on issues such as the extent of the arbitral tribunal's priority over the power of state courts to decide on the validity of the arbitration agreement, whether courts examine the validity of the arbitration agreement with full power of review or only on a prima facie basis, whether in case of a valid arbitration agreement the court must decline jurisdiction or only stay the proceedings, and whether, if the dispute has already been submitted to the arbitral tribunal, the court must decline jurisdiction on this ground alone or not. These are just a few examples. Why do approaches to the Kompetenz Kompetenz principle differ worldwide? Is the lack of uniformity a problem? Is more uniformity desirable? Is it achievable? This panel will discuss the differences in the application of the Kompetenz Kompetenz principle in greater detail and also debate potential answers to these questions. First, Dario Moura Vicente will present the Portuguese perspective and compare it with other European systems, namely England, France, and Germany. Second, Eleonora Coelho will present the Brazilian approach to the Kompetenz Kompetenz principle. And then Danielle Morris will discuss the US perspective and the issue of uniformity. After that, Chris Parker will try and answer the big question: is uniformity a dream? And finally, I'll ask a few questions to the panel members and also take some from the audience, hopefully. Well, starting with Dario. Dario is a full professor at the Faculty of Law of the University of Lisbon, where he has taught over the past 30 years civil law, comparative law, private international law, and arbitration law, among others. He has participated as arbitrator counsel and expert in a number of domestic and international arbitrations. He was a member of the drafting committee of the 2011 Portuguese arbitration law and is the chairman of the Portuguese Arbitration Association. Dario?
Thank you. So, good afternoon. Thanks to the organizers for inviting me to be here today. It's a great honor to address this qualified audience that we have here. And I must say I feel absolutely at home with so many Portuguese-speaking persons among the audience. So the topic I will be addressing is Kompetenz Kompetenz from the Portuguese perspective, but I will also try to make some comparison with other legal systems, particularly European legal systems. A brief word to begin with on the issue that is at stake here. Most states have undertaken, as André has just mentioned, via the New York Convention to recognize and enforce arbitration agreements. But the question arises as to who decides on whether there is a valid and an enforceable arbitration agreement. Should it be a state court? Should it be the arbitral tribunal? Or should it be both of them? So I will try to give some answers in this respect. And before coming to the law itself, I think a word is in order in respect of the interests that are at stake in this matter. I think two basic interests are at stake on this topic. On the one hand, there is an obvious interest in ensuring the arbitral tribunal's legitimacy to adjudicate on the substance of the dispute that it has to decide. And of course, this to an extent depends upon the validity of the arbitral agreement. But on the other hand, we have an interest in ensuring the efficiency of arbitration as an alternative means of dispute resolution, and this may be jeopardized if state courts can interfere excessively in the determination of the arbitral tribunal's jurisdiction. So under Portuguese law, a valid and enforceable arbitration agreement confers the arbitral tribunal jurisdiction to decide on the issues that are comprised within the scope of that agreement. That is the so-called positive effect of the arbitration agreement. Correspondingly, the arbitration agreement usually prevents state courts from deciding the same issues that are allocated to the arbitral tribunal. So a court before which an action is brought in which the same issues that pertain to the jurisdiction of the arbitral tribunal are raised should refrain from deciding those issues and refer parties to arbitration. That is the negative effect of the arbitration agreement. This negative effect of the arbitration agreement is expressly enshrined in the Portuguese arbitration law of 2011, Article 5, paragraph 1 of which states that the state court before which an action is brought in a matter which is the object of an arbitration agreement shall, if the respondent so requests, not later than when submitting its first statement on the substance of the dispute, dismiss the case. However, the validity and the enforceability of the arbitration agreement may be contested by one of the parties as a preliminary issue in the arbitration, and then the issue arises as to who is competent to decide on that point. As a matter of principle, that issue may be decided by the arbitral tribunal, and this is what we call the Kompetenz Kompetenz. For this purpose, the arbitration agreement is deemed to be an independent agreement from other clauses of the contract. Portuguese law also enshrines these rules in Article 18, paragraphs 1 and 2, according to which the arbitral tribunal may rule on its own jurisdiction, even if it has for this purpose to assess the existence, the validity, or the effectiveness of the arbitration agreement or of the contract of which it is a part. Kompetenz Kompetenz and this autonomy of the arbitration agreement are expressions of the interest that I mentioned a few moments ago on the, in ensuring the efficiency of arbitration as a means of settling disputes. Absent these rules, tribunals would have to suspend proceedings whenever these kind of issues were raised by any of the parties and refer them to the courts. And this would in turn potentially entail some delay in adjudicating the merits of the dispute. In any event, the arbitral tribunal's jurisdiction to decide on these topics, notably its own jurisdiction, is seldom an exclusive one. Courts may, within certain limits, also rule on that issue, at least before arbitral tribunals are constituted. As I mentioned earlier, Article 5, paragraph 1 of our arbitration law requires state courts before which an action is brought in a matter which is the object of an arbitration agreement to dismiss the case. But this is so unless the court finds that the arbitration agreement is clearly null and void, is or has become inoperative, or is incapable of being performed. So under Portuguese law, state courts are allowed to carry out a prima facie control of the validity and enforceability of the arbitration agreement, but they cannot go further than that. Accordingly, one may conclude that arbitral tribunals in Portugal have the priority in deciding issues affecting their own jurisdiction. This is what one may call the negative effect of competence competence, as opposed to its positive effect, which I referred a few moments ago. Through this rule, Portuguese law has endeavored, on the one hand, to prevent delaying tactics by the party resisting the arbitration, and on the other hand, to concentrate the disposal of issues concerning the validity and the enforceability of arbitration agreements in the arbitral tribunal, since the arbitral tribunal is deemed to be the most appropriate forum to decide on these topics. So one can say that there is a certain favor arbitrandum that underlies Portuguese law in this respect. Now, French law takes this idea further in this particular respect. Once the arbitral tribunal is constituted, it has exclusive jurisdiction to decide issues concerning its own jurisdiction. So accordingly, state courts may only address jurisdictional issues before the arbitral tribunal is constituted. So one may say that the negative effect of Kompetenz Kompetenz finds its most radical expression in French law. French courts must decline jurisdiction to decide the dispute once there is a pending arbitration and the party claims that the dispute is subject to arbitration, even if the invalidity of the arbitration agreement is obvious. Other European legal systems, such as the German and the English ones, allow state courts to undertake a much broader scrutiny of the validity and the enforceability of the arbitration agreement. This is patent, I submit, in Section 32 of the English Arbitration Act, for example, according to which the court may, on the application of a party to arbitral proceedings, determine any question as to the substantive jurisdiction of the tribunal, and also in paragraph 1032, section 2 of the German Code of Civil Procedure, according to which, prior to the constitution of the arbitral tribunal, an application may be made to the court to determine whether or not arbitration is admissible. So no priority is given by these two legal systems to arbitral tribunals when deciding these issues. The English and the German legal systems thus only enshrine the positive effect of Kompetenz Kompetenz, not the negative one, which we find in Portuguese and French law. Now, whenever a state court is allowed to decide the issue of the arbitral tribunal's jurisdiction, the question then arises whether the arbitral proceedings are allowed to commence and continue while this issue is pending before that court. Under Portuguese law, Article 5, Section 2 of our arbitration law, in that case, arbitral proceedings may be commenced and continued, and an award may even be rendered while the issue is pending before the state court. But, according to Article 5, Section 3 of the same law, the arbitral proceedings shall cease, and the award may therein shall cease to produce its effects, if a state court decides, by means of a final ruling, that the arbitral tribunal is incompetent to settle the dispute that was brought before it. So in what concerns the jurisdictional issues that I've been addressing here, the final word is thus deferred by Portuguese law to state courts. Arbitrators may be the first judges to decide on their own jurisdiction, but they are not the sole judges of that issue. In Portugal, the negative effect of Kompetenz Kompetenz is thus essentially a rule of chronological rather than hierarchical priority of the arbitral tribunal in the disposal of issues affecting its own jurisdiction. Again, French law goes further in this respect. In international arbitration, French law allows, by way of a specific agreement, that parties may at any time waive their right to bring an action to set an arbitral award aside. So in this case, the arbitrator's decision on their own jurisdiction will in fact be the last word on that issue. A comparison of these legal systems shows therefore, that no consensus exists in respect of the allocation of jurisdiction between courts and arbitral tribunals regarding the determination of these issues that may affect the tribunal's own jurisdiction to decide the merits of the dispute. All these systems do, in fact, recognize the tribunal's Kompetenz Kompetenz. However, while some of them, such as the French and the Portuguese ones, give arbitral tribunals priority in deciding such issues, thus adopting the so-called negative effect of Kompetenz Kompetenz, other systems, such as the German and the English ones, do not do so and opt for a system of pure concurrence, which only allows room for the positive effect of Kompetenz Kompetenz. And even among the former of these systems, there is no uniformity as to the extent of the negative effect of this rule. French law opts for a principle of exclusive jurisdiction of arbitral tribunals once they are constituted to decide on their own jurisdiction, and allows the exclusion of state courts' jurisdiction to annul arbitral awards on grounds of lack of jurisdiction, whereas Portuguese law has adopted a more mitigated approach, according to which the final word in this respect belongs to state courts. In sum, and to conclude, three basic approaches can be identified from my point of view on this topic. The first one being the adoption of concurrent jurisdiction of arbitral tribunals and state courts as to the determination of preliminary issues affecting the arbitral tribunal's jurisdiction to decide the merits of the dispute, with priority of arbitral tribunals. Arbitrators are the first judges of their own jurisdiction, but they are not the sole judges. This is the Portuguese approach. Second approach is the approach according to which there is concurrent jurisdiction of arbitral tribunals and state courts, but with no priority of the former of the two. So they are both judges of the arbitral tribunal's jurisdiction. This is the English and the German approach. And thirdly, we have the approach according to which there is exclusive jurisdiction of arbitral tribunals to decide these issues once they are constituted. Arbitral tribunals, at least when annulment actions have been excluded by the parties, are the sole judges of their own jurisdiction. That is the French approach. Is unification feasible in this respect? Well, this issue will be addressed by one of our panelists in a few minutes, but I have my doubts in this respect. I think that the differences that I have just pointed out in this respect stem from relatively deeply rooted factors, different concepts of arbitration. There are jurisdictional and contractual views of arbitration that heavily influence approaches in respect of Kompetenz Kompetenz. There are different policies at stake here. Many countries tend to favor arbitration, but pro-arbitration policy, such as that which is implicit in the negative effect of Kompetenz Kompetenz, is far from being universally adopted. And there are also different judicial idiosyncrasies. In some countries, state courts' interference in the determination of the arbitral tribunal's jurisdiction may implicate serious delays in disposing of the merits of the dispute, while in other countries, this may not be the case. So the need for an exclusive competence of arbitral tribunals in respect of this type of issues is not the same everywhere. Thank you for your attention.